Good morning, everyone. Some of you who might have been at the last event that we were at, or that we had down here, might recall me being pretty harsh on the American Health Care Act, and that was the Republican bill that was introduced back in March to repeal significant sections of the Affordable Care Act. I was harsh on it because we knew back then that what came out didn't have a chance of passing, right? And we knew that it would never have the votes, and that it was a lot of political posturing, and that the song and dance with John McCain doing the dramatic no vote back in July, voting down the Better Care Reconciliation Act, which was the Senate version of that bill, wasn't terribly surprising. And then what happened this week where they said, we're not even going to bring this Graham Cassidy thing up for a vote, not terribly surprising. Why do I say that? Okay, why do I say that these efforts and the failure of these efforts to repeal large sections of the Affordable Care Act have not been successful? Why that has not been surprising? It hasn't been surprising because in 2010, the insurance market fundamentally changed. It fundamentally changed in a couple different ways that once they changed in that manner, it becomes very difficult, if not possible, to repeal, both from a practical perspective and also from a political perspective. Why do I say that? What's in the Affordable Care Act that is unrepealable? Number one is no more medical underwriting for pre-existing conditions. I'm still astounded that I see human beings out in America lobbying to repeal this provision of the Affordable Care Act. That's astounding to me, and it shows either a lack of understanding with what that means or a lack of understanding with how the Affordable Care Act works, which I'm going to bet on the latter. Okay, why do I bet on the latter? Because 30% of the American public still doesn't realize the Affordable Care Act and Obamacare are the same thing, right? So I'm going to bet on the latter. That was a study that was done that we've known for a long time in our industry that people really don't have a good understanding of why this works. And I blame a lot of parties, including the previous administration, for not explaining it effectively, and for Democratic congressional leadership from running away from it as fast as it was passed, right? So no more pre-existing conditions. That's unrepealable. That's a one-way street. Supplemented with no more pre-existing condition exclusions is something called essential health benefits. And essential health benefits is a concept that states in the Affordable Care Act that 10 buckets of services that you would expect to be covered in your health insurance plan that were not necessarily covered, especially in Pennsylvania, before the passage of the Affordable Care Act would have to be covered after the Affordable Care Act. It includes everything you would expect it to include: prescription coverage, maternity care, cancer coverage. Essential health benefits say that, okay, there's not only no more pre-existing condition exclusions, but they're not going to winnow down your coverage and say, yeah, we're not going to underwrite you for a pre-existing condition, but your condition's just not covered because it's not an essential health benefit. So those two provisions go hand in hand. Third is no more annual or lifetime limits. No more annual and lifetime limits for essential health benefits. So those 10 buckets of services that you would expect the health plan to cover no longer have annual or lifetime limits. Meaning that previous to the Affordable Care Act, you could have an annual limit of $1 million. Or if you incur $1 million of treatment in a year, you're on the hook for every dollar above and beyond that. Anybody who's gone through a serious cancer diagnosis can tell you that you could burn through $1 million in a year, no problem. Or if you've ever had a relative or you yourself have ever had a transplant, you can blow through $1 million a year. That doesn't exist anymore. The lifetime limits where $5 million was pretty common, where if you incur $5 million of treatment in a lifetime, every dollar above and beyond that, you're on the hook for. My plan that I had when I was a law student had a $100,000 cap for organ transplant. And if I had actually needed that liver transplant that I thought I was definitely going to need when I was a law student, I would have been in trouble. It's a $600,000 procedure at minimum. It would have ruined my life. Americans don't face any liability like they do in healthcare. Your house is your house. Your house has a max liability, right? Healthcare, though, you have no idea what your liability is, but it can be $1 million plus in a given year. So no more annual lifetime limits, essential health benefits, and no pre-existing condition underwriting. What's the last one? The Medicaid expansion. The Medicaid expansion goes hand in hand with trying to expand access to payer coverage across the country, and states had the option of whether they're going to sign on to the Medicaid expansion. Pretty much every state in the Northeast signed on to it. Pennsylvania, New Jersey, Delaware all signed on to the Medicaid expansion. This was an expansion that expanded Medicaid eligibility to all individuals, regardless of circumstance, personal circumstance, as long as their household income was under a certain threshold, and the threshold's about $17,000 a year. For an individual, roughly $40,000 a year for a family of four. So if you show up and you type it, if you log on to healthcare.gov, you type in your household income, you fall under those thresholds, it automatically directs you to Medicaid. In Pennsylvania alone, there's about 700,000 people on Medicaid, and that number is growing every day, especially with the blossoming opioid epidemic that's hitting Pennsylvania pretty severely right now. So the Medicaid expansion, as you saw, if you were following the news this week, Susan Collins, Murkowski from Alaska, they have real problems with a bill that aims to get the Medicaid expansion because their states are battling with the same problems that Pennsylvania are, where there's underemployment and on top of that, massive pain medication abuse. So those provisions together are unrepealable. Unfortunately, the negative effect of some of those provisions, right, is one, that in order to make no pre-existing condition exclusions work, you have to have an individual mandate. You have to have an individual mandate. It does not work otherwise. If you can wait until you get sick and walk to an insurance carrier and say, I want insurance now, the market would completely explode. So what the economists in Massachusetts said when Mitt Romney was passing the 2006 Massachusetts healthcare law is that in order to have no more pre-existing conditions and essential health benefits and no annual or lifetime limits, you have to have a negative incentive to drive individuals into the market. They have to be driven into the market. That's an unpopular provision. And it's about to get significantly more unpopular because the penalties actually mean something this year. The penalties are actually pretty substantial this year if you were to go without health insurance. So repealing the individual mandate, but giving everybody fantastic, inexpensive health care that's as robust as the health care that's available right now as a result of the Affordable Care Act is an impossible task. It's an impossible task. Similarly, on top of that, in order to remove people from the individual risk pool to put them into the stable employer-sponsored market, the employer mandate plays a role as well. And the employer mandate says that if you have 50 or more full-time employees, including full-time equivalents during the preceding calendar year, how many times do you think I've said that sentence? Right? If you have that number, you are subject to a mandate where you have to offer your full-time employees working 30 hours a week or more health insurance or risk penalty liability. What the government was trying to do there is they were trying to prevent employers from dumping their employees to the individual marketplace to take subsidy dollars, which are taxpayer funded. And they were saying, if you're not going to offer health insurance, you're essentially going to pay for the subsidies that your employees are going to go receive. Relatively unpopular with the employers that I work with, especially if it caused them to offer coverage for the first time. If employers had been historically offering coverage, the thing they don't like is the ACA reporting, and I understand that. The 1094Cs, 1095Cs, anybody in HR who deals with that fun task can understand what I'm referencing here. So those are relatively negative provisions that are intended to make the Affordable Care Act work. One of the also unfortunate consequences of having insurance carriers take on unlimited liability for claims is your premiums become much more expensive. People experience roughly about 30% premium increase on the individual market between 2013 and 2014 when the essential health benefits provisions of the Affordable Care Act took effect. Their plans are more expensive because they cover a lot more and there's unlimited liability. However, if you can't afford to pay the $500 a month for an individual silver level policy, it's hard. It's very hard. And that policy most likely has a $6,000 deductible or a $5,000 deductible because in order to get the insurance carrier lobby to sign on to the Affordable Care Act, they had to permit the government they had to permit the carriers to front load policies. Every policy now, just about, that's being offered in an employer-sponsored platform has a high deductible. And it has a high deductible to try to slow utilization until you hit that deductible, right? So that people might pump the brakes and say, should I go to an emergency room or should I go to urgent care? Should I ask for a name brand pharmaceutical or should I ask for a generic? You know, ways to try to mitigate the pace at which people spend with healthcare. Once you hit that out-of-pocket maximum, the carrier is on the hook for every dollar above and beyond that, which is novel as a result of the Affordable Care Act. But getting there can be challenging for people. So We have a population that doesn't fully understand all the provisions of the Affordable Care Act. We have a Congress that's campaigned for 7 years on repealing and replacing the Affordable Care Act. We have premiums that are skyrocketing, and we have a really tough situation right now. It's a really tough situation. So I say all that sunny news to say, here's the $1 million point. Nothing has changed. Nothing has changed yet. There hasn't been any substantive change to the law that impacts what an employer's obligation is and what an employee's obligation is with regard to the individual mandate. It's all, the Affordable Care Act is still the law of the land. What are we doing at Kistler Tiffany Benefits is we're having the healthcare reform discussion that we believe needs to be had with our clients directly. What do I mean by that? Everything that you read about the news with the Affordable Care Act focuses on payer reform. It's payer reform, it is not healthcare reform. Payers are just one cog in the wheel of our massive $2 trillion a year healthcare industry. We're not talking about pharmaceutical repricing. We're not talking about billing transparency with providers. We're not talking about inefficiencies in claims processing, which those top 3 items right there account for over $600 billion a year in wasteful spending in our system. We're having those conversations at the employer-sponsored level. We're having those conversations with how do we achieve efficiency with pharmaceuticals? How do we adopt the Medicare provisions that allow for reference-based pricing in the private sector and embed that in the group plan to where when someone shows up to a hospital and the hospital is going to bill them $6,000 when they would only bill Medicare $1,200, how do we embed that type of pricing structure into a group health plan, which we're doing right now in the private sector? We're saying to hospitals, look, we know you take Medicare all day long, you're going to take Medicare plus 20%. How are we giving our employees that we work with transparency tools so that they know what the cost of coverage is when they show up? If they have a high deductible plan, they're going to have some sense of what they're going to pay. And then we're talking about wellness. And wellness is the biggest cost driver. The lack of wellness is the biggest cost driver in a group health plan that can be addressed. We're talking about wellness programs, especially as more employers start to look at self-funding. So nothing has changed. We have to keep on doing what we're doing from a governmental regulatory perspective. However, on the group level and when we talk to employers directly, we're coming up with a lot of interesting strategies that get at the heart of healthcare reform and the conversation we should be having on a national level within the universe of your individual company. So with that said, thank you all very much for coming this morning. Very excited to have a partnership with Eric Meyer. Eric is the man. And he is a fantastic speaker, really entertaining as well. I felt more surly today than I did entertaining, Eric. I think I'm so tired of CNN debate night. But
I learned that ACA and Obamacare aren't the same thing, so thank you.
Yeah.
Aren't the same thing, excuse me.
Yeah, so Eric, we're really happy to have the partnership with Eric, and just the pivot to why we partner with Dilworth Paxson is, our relationship with our clients is we want to be the first call for every issue, whether it's HR related, whether it's payroll related, whether it's benefits related, we want to be the first call. But there comes a time when you're dealing with a very serious employment situation with one of your employees where your benefits firm is not the appropriate party to be contacting. That's why we partner with Eric. Eric is here, and I always recommend to our clients that they give Eric and Dilworth Paxson a good hard long look when they're looking who they want to partner with as an external counsel for when they encounter employment law issues. I couldn't recommend Eric highly enough. Read the stuff he's published. He's published all the time. His name's everywhere. You'll see this morning that he's fantastic. So Eric, I'll turn it over to you and look forward to the presentation.
Thank you.
Age Discrimination and Employment Act. We don't do this much, the Age Discrimination and Employment Act. The sexy, relatively speaking, sexier things are like Americans with Disabilities Act and leave and now LGBT issues. There are a lot of kind of issues that are grabbing the headlines. Frankly, the ADEA hasn't changed much in the 50 years since it went into effect. Went into effect actually in 1968. Hasn't really changed much. We've seen the threshold number of employees for an employer to qualify go from 25 down to 20. What else? We've had the Gross Supreme Court case a few years ago, which essentially made it a little bit more difficult for employees to prove that they were discriminated against based on age. I won't get into the minutiae of that, but that's the long and short of it. And we've had the Older Workers Benefit Protection Act, which changes how we draft severance agreements for employees who are either in a single employee layoff or in a multi-employee layoff. Trust me, take my word on it, this isn't necessarily a plug for Dilworth, this is just a plug for law firms in general. The law firm of Google and Bing is not your friend when you're trying to figure out, what do I put into a severance agreement for someone who's over 40, because you're bound to screw that up.
I think it's just so key, and even the importance thinking, well, we used this in severance agreements in the past. Well, EEOC has also looked at severance agreements that I'm sure a lot of employers have used, but could it be chilling people from exercising their rights under our statutes? So we've even gone a little bit broader beyond age, but looking at them that, if it has language, some of the provisions, and one that we challenged, and we weren't successful for reasons not on the merits, on how we tried to resolve the case before going into litigation, but some of the language like keeping it confidential, contacting the HR or general counsel if EEOC contacted an individual. Even though it did have the standard provision, this is not going to restrict you from filing a charge with the EEOC. But we argued that overall it was kind of more legalese, and would it be understood by a person, or would it maybe make people be reluctant to respond to an investigation? Was another, issues about pay, if you're talking about compensation. So it's just, I think, really key, even if you think something, hey, this was reviewed, the importance of having things reviewed again because it's ever changing.
Mm-hmm. There are going to be many points today where Mary and I agree to disagree. Okay? I think a confidentiality provision in a severance agreement is just fine. I don't think any court's going to question it, but that's okay. But there are certain things we can agree on.
Mm-hmm.
Like when you're doing a severance agreement for someone who's over 40, you got to tell them, we recommend that you go see a lawyer. We want you to go see a lawyer. If you take that language out because you're thinking, we don't want to.
What's the lawyer going to say? They're going to cause problems.
And you pay the severance amount, you have funded
Them going to the lawyer.
them going to the lawyer if they want to bring an age claim, because that age release is not binding without that language.
Mm-hmm.
You have to give them 21 days, up to 21 days in which to consider the agreement as if it's one person getting laid off. If it's an exit, what they call an exit incentive program, or a group layoff.
And group isn't huge.
Group
can
could be
be
two. Group could be two. So when you're laying off two people for performance, that faint whistle should go off, a little red flag. This may be a slightly different situation. When it's two or more people as part of a program, you have to give them up to 45 days in which to consider the release. And also there is what I'll call a matrix, a schedule that gets attached to the release. So imagine a bigger situation when you have 10 people getting laid off. Some are over 40, some are under 40. And when you're laid off, the first thing you don't necessarily think of is, well, I was discriminated against. You may think, well, this wasn't my fault. That's kind of natural. Most employees don't own up to the fact that they're being separated because of something they did. But or maybe not.
Or some other reasons might be there.
Maybe. But when you get that severance agreement from the employer, you're going to see a schedule on the back. And the schedule is supposed to, if it complies with the law, list the ages of all the people who were selected for layoff and all the people who weren't selected for layoff within the same job classification, location, physical job location. There's any number of ways to kind of classify it. But if you look at that matrix and you see, the ages of the layoffs were 50 and 60 and 55 and so on and so forth, and all the people who were capped are 21, 22, 30, and you start
40,
to think,
yeah.
why
Right.
are older people, being targeted? And that may suggest to you that maybe I should go see a lawyer, take the employer's advice, go see a lawyer and see if there's something here. So these are things that we definitely
Yeah.
cannot
I think
get
just
around.
like a kind of informed consent. And I think many people, even when presented with the severance agreement and see that matrix, they might not choose to go to EEOC. They still often sign the release, but at least if you're giving that information and you're giving them that 7 days to rescind it, or the time period to rescind it, let them think about it. I think it alleviates the problems down the line. I think that maybe I have an overly idealistic view on this, but I think giving people the information, they can make an informed decision, but you have to at least comply with OWBPA. And there's no sense going through the process and not making sure you checked all that off.
But our goal today, this is all definitely true. This is some of the minutia of the Age Discrimination and Employment Act. But our goal today is really focusing on kind of the bottom points and helping your workforce attract, hire, and retain older workers. You'll see when we get to this one. Some employers, you happen to go on Craigslist and you run searches for buzzwords like young and what digital native is.
Digital native.
Is another one. Some employers, they don't hide it. They're specifically looking for young workers. That could be that probably is a problem. But let's start off with a quick video. And yeah, this is about 4 minutes, and I like it. We'll see. Hopefully it plays. Oh, whoops! It
Oops,
doesn't.
back one.
Let's
Yeah.
use the mouse. There we go.
Hey, how's it going? You can stand right there. That's your mark. How you doing?
I'm great. How are you?
Great. Just tell us your first name and your age.
My real age?
My name is Pablo. I'm 25 years old.
My name is Daniela, and I'm 19.
24, 35.
31. 33.
I'm 26 years old.
What age do you consider to be old?
Late 40s.
I feel like 33 and 20, so I'd say like 40 is old.
I'd probably say 50s.
I'd like you to show me how an old person would cross the street. Show me how an old person would send a text message. How might an old person do a push-up? What about jumping jacks? Okay, hang on. There's someone I want you to meet.
Hello, I'm Birch. I'm 66.
Hi, I'm Daphne, and I'm 68. I'm Dee, and I'm 55.
George Fassbinder, 75.
My name's Parvati. I'm 70.
Nice to meet you.
Nice to meet you. We're going to give you about 2 minutes to teach each other something that you are good at.
I can teach you a jump that I do.
Okay, please.
Both of your legs go up, and your arm goes up, and your left arm goes like to the side.
Okay.
1, 2, 3, lift. 1, 2, 3, and bring it to your heart, and bring it to your heart. Add your head in, yeah.
I'm going to try to get you balanced. Ends up.
Two, 5, 6, 7. So when you come out of the turn, either way, you go back to that place.
Over, now forward. Over, yeah.
Square like this, and we hook. Hook. Jab, cross, hook, and then we go like this. Right?
1, 2, 3.
Now, what age might we consider to be old?
Probably 80 or 90. He could just do everything that I told him to do. An age that I consider to be old now might be kidding me. It really changed my thinking of what old is.
You've taught me something today. Clearly, there's no way she's old, you know?
Now I know from today, hey, I don't look at age.
At my age, I feel like I did when I was in my 20s.
There's so many things that I still want to do. There's so many things that I can do. As long as I'm growing and learning, then age doesn't matter.
When people start stopping, that's when they start getting old.
Thank you. Thank you so much.
Thanks, Daphne. It was great meeting you.
How long have you been doing this? Is this a new skill?
40 years.
So the moral of this is today's going to really be a millennial bashing session.
We're all on board with that. They're not protected.
They're not protected.
No.
So, a little bit of background on the Age Discrimination and Employment Act, a little bit more. As we said, this was the 50th year celebration of the ADEA. There was, there was a big public meeting in Washington, D.C. You want to tell the audience a little bit about that?
Yeah, so we had public hearings, bringing experts, really wanting to look at why are we still having age issues, and then trying to focus on how can we prevent it. So those are some of the things we'll hit in the slides later for the recruitment, for the strategies, increasing diversity, but not treating age discrimination kind of like an afterthought, because I think that the AARP clip is a good little summary of it. We should always be looking at ability, not age, just like we should be looking at ability, not race, or not sex, or anything like that. So why is age kind of like the afterthought sometimes in the diversity planning? And I think as we have more tech-heavy jobs, as the workplace, even in jobs that might not have been considered tech, like think about a lot of mechanical jobs or manufacturing jobs, so many jobs have a tech component, and are we dealing with assumptions on that you can't teach an old dog new tricks if you're have to have that kind of technology, if you haven't been born using that technology, you're not a digital native, are you going to be able to compete? And having those stereotypes is hurting everybody. I think one of the things with the acting chair and the administration, looking at increasing employment opportunities, and it just it helps anybody's workforce and productivity when you have the talent of everybody. So there's that self-interest for employers to make sure that you have a broad variety of talents and not just think, oh, if we have some kind of tech aspect, it has to be somebody under 30 because they're a digital native.
Yeah. So you can read the bullets up there. This last one, it protects workers who are 40 or older. I want to touch upon that a little bit more. First off, if you have two employees who are over 40, right? Mm-hmm. You have a 55-year-old employee and you have a 47-year-old employee. 55-year-old employee is laid off. 47-year-old employee who works in the same position is kept. Can the 55-year-old claim age discrimination? Both are over 40? Yes, they could. As long as there is a significant enough disparity between the ages. 55 and 54 is going to be tough.
Yeah.
55, 47, not as tough. Don't forget about state law and local law as well. So Pennsylvania, we're pretty employer friendly. We basically, all of the state employment statutes are basically follow federal. There's nothing that Pennsylvania really does for its employees to make the law more employee friendly. But if you go across the river to New Jersey, it's definitely not the same way. It's very employee friendly. So
even the city of Philadelphia with the city ordinance,
that's exactly right. Even within the city of Philadelphia too, whether it's not just here with age, but certainly sexual orientation and gender identity are recognized protected classes. They are not recognized at the state level. There are pretty robust pregnancy accommodation rules in Philadelphia. We have the ban the box rule for hiring. Currently being litigated right now is whether you can ask applicants about their salary history. That was supposed to take effect, but the Philadelphia Chamber is litigating that right now. in the Eastern District of Pennsylvania. So keep in mind, if you're a multi-state employer, on the age discrimination piece, the threshold might not be 40. If in some states, if you favor someone who's 20 over someone who's 30, that could still be age discrimination under state law. So keep in mind, if you're in Pennsylvania, it's 40. But if you're in other states or other localities, think about check what the local law may be.
Eric, before we move on,
Yeah, sure.
when you're bringing up the salary history within the city, I mean, that's, to protect against the goal to stop the pay discrimination based on gender. Is this having an impact that women, if they've been paid less at a prior job, and the first thing is what's your starting salary, are you going to be perpetuating the age discrimination? But you just, as you always do, maybe think of something else. If you're always focusing on salary history, is that going to affect older workers? Is that when you're looking at salary history, and I don't have an answer, and I'm not saying not to consider it, but is this one of the things that keeps people from getting jobs? The assumption maybe somebody's not going to take a pay cut, or you're making a little bit more than we have for this range, so we're not going to hire you. Is that something that's keeping older workers from getting jobs after they've lost a prior job, or if they want to change a career, go to a new organization?
I don't know the answer to that, but I'll give you a corollary to that. And it rings true in the legal industry. I mean, how many times have we looked for, when I say we, I mean as law firms generally, looked for an associate that has 3 to 5 years of experience, 5 to 7 years of experience? Well, when you cap it at 7 years, are you unintentionally discriminating against men and women who have been out of law school much longer? I mean, it's generally the 3 to 5 year associate is probably going to be a younger person. A 3-year associate is probably going to be a younger person. But when you don't put a cap on it, then you expand the pool of applicants. And look, if you can bring someone in who's been practicing for 20 or 25 years, and they're willing to come in as a fifth year, what would be the equivalent of a 5th year associate, you get the benefit of all that additional knowledge and experience. That's pretty good value. So it's funny, I was talking, I won't say who it was, but I was talking to a plaintiff's lawyer the other day, an employee rights lawyer who was looking to fill an associate position, and I said, what are you looking for? And this person told me 3 to 5 years. I said, you may be discriminating there.
Well, you want to look in the mirror and see that part, but think about these things.
I don't think this person's going to change their advertisement, but it certainly was food for thought. There are a couple different ways that the Age Discrimination and Employment Act comes into play in the workplace. A couple different claims that an employee could bring. The first one is what I will call the disparate treatment claim. That's the one where you treated someone who's younger than I am better than you did me, whether it's in hiring, firing, promotion opportunities, training opportunities. It says it all up there. 1-to-1, usually, this person was treated better than I was, that's disparate treatment. I'm going to have to prove, and this is that gross case I alluded to earlier, I'm going to have to prove, if I'm the plaintiff, that age was the motivating factor, not a motivating factor, but really the motivating factor as to why the employer did what it did. And that's significant.
But it's not insurmountable.
It's not insurmountable either.
I think initially it was like, what's going to happen with the EEOC and age claims? We are still investigating, making findings, and in some cases litigating because we think we have the evidence to show that.
We're lawyers. I get to tell a war story.
Yes, please.
So
That's what we're here for. I love them.
It's not insurmountable. I had a case a couple years ago that went to trial. We represented an emergency medical service. We had a complaint that was made about the level of service that our client was discharging generally. So to address that, the client decided that they would attempt to recertify all of their EMTs. Okay? So they bring in a third-party trainer to recertify. And everyone's getting down there and doing the compressions and showing how great they are at CPR, except for this one woman, this one EMT who didn't have the foggiest idea as to how to perform CPR. I said, okay, here's the defibrillator. Show us how this works. She's trying to pry it open. She can't figure where the on-off switch is. And we said, you're fired. Now, unfortunately, there was a claim by eventually the plaintiff, our former employee, that her manager told her on the way out, you're too old to work here. We denied that, but needless to say, we went all the way to a jury trial. And you say it's not an insurmountable burden. Well, on a Thursday afternoon, we had finished our closing arguments, and the judge decided, rather than send the jury home for the day, we're going to start deliberations late in the day. And the jury went out for about a half hour, and they came back in and said, Judge, we have a question. And the judge said, okay, jury, what is your question? And the jury said, how do we factor in unemployment into back wages? The only worse question could have been, Judge, do you have a calculator?
Yeah. Is there any cap on how much money we get this one, Judge?
Right. So my heart sank. The jury also asked to be recharged on the instructions for age discrimination, which the judge said, okay, I'll recharge you. And they said, could we keep a copy of the charge in the jury room? And I was like, yeah, take the charge with you, go. And fortunately, the next day they came back with a defense verdict, which was nice.
I'm sure that was a long night for you all.
It wasn't great, but we're going to talk in a couple slides about a different verdict that went the other way. Fortunately, I wasn't involved in that case. But yeah, it's not an insurmountable burden to show that age was the but-for reason. Certainly when someone says, you're too old to work here, if the jury buys that, and they don't buy the employer's otherwise legitimate business reason for terminating an employee's employment, then you've got an age discrimination claim. There's also the hostile work environment, right? So just like you could have one based on sex or gender or race or religion or national origin, it's no different. You could have one for age. And you can think of all the different names that you could call someone. I won't use them here, but generally they're all variants of old, okay? And when you start calling...
When are you going to retire?
Right.
The grandma, the grandpa. But I was talking, we had a training session, and one of the trainers on harassment issues, a new module EEOC is rolling out, but she was talking about doing training with a company. So they brought her in to do training, and she talks about age harassment. And so one of the guys comes up and he says, oh, so I shouldn't talk to Mary and pat her on the head and call her grandma? You know, the other employee was a woman, a little bit older, gray hair, in the middle of training. I mean, I think sometimes, no matter how we talk about it, some folks just don't get is still wrong. It's not funny just because it's somebody over 40.
Mm-hmm. The last one is I won't go into any sore subjects for the EEOC. We'll talk about some cases, one case in particular down south, but in any event.
Every time you say, I won't talk about any sore subjects, I'm just waiting 3 more slides for you to do
right.
it. That's okay.
I won't mention them by name. But you can also have what's called a disparate impact claim. We know this. The Supreme Court has said that if you have a rule that is neutral on its face, right, but it has the tendency of singling out a particular protected class, then if you don't have a good business reason for it, just in lay speak, you could have a disparate impact claim. You often see this, or you're most likely to see this with gender, race, national origin. Not as much with age, but we talk about, and we'll talk about it in a little bit, big data, using algorithms to hire. Maybe the person who programmed that original algorithm was some 25-year-old, or is that Generation Z now? I don't even know. It's millennial Generation Z, and it kind of propagates itself, or something easier than that, right? What if you're focusing your hiring efforts just on like LinkedIn? You're only going to LinkedIn to hire. I'm fairly certain that LinkedIn, the average age of LinkedIn is lower than kind of the job pool. generally, right? So you're probably going to get a younger demographic using LinkedIn, or pick another social media platform that we know to have a younger usage demographic. So you're not intending to discriminate against older people, but it may have the effect, the impact of discriminating against older people. But see, here's kind of the weird issue. There's not a clear answer as to whether disparate impact claims can be brought by job applicants. One court has said no, EEOC says yes. The EEOC will continue to process claims of individuals who feel that they've been a victim of disparate impact in hiring based on age, but that issue is hazy, I think, at best. So now we're going to get into kind of the obligatory statistics slides, and talk about changes. I remember reading something on the EEOC slide deck that you were kind enough to give me, that this looks nothing like when I put this together. But I think the statistic was in 1967, maybe 5% or 10% of the workforce, were 5 or 10% of employers were actually seeking folks who are over 45 years of age. It was some really low number.
You know, and we get so used to thinking on this, and when you talk about like why 40, you know, because we're 60 is the new 40 and 40 is the new 20 and all of these things. Like why 40? That doesn't seem old to us, you know, not the AARP blurb notwithstanding. So what was the reason for it? And it was because of those stark statistics that, you know, when employers were looking for jobs, they would literally ban people over certain ages, would not accept applications, or, you know, make it very clear that they wanted people under 45, under 40, not even consider them and their ability for a job.
The Age Discrimination in Employment Act was not a controversial statute at the time. You go back a couple years to Title VII. That was a controversial statute at the time. We had gotten past race. We understood that race needed to be a protected class. But we had this Virginia congressman named Howard Smith who tried to put gender in at Title VII as a poison pill, thinking that if I put gender in as a protected class at the last minute, no one's going to take this seriously, it's not going to get passed. Well, lo and behold, it did.
And this lobbying, like, yes, you're right, gender is an issue. We do need to have it in there.
And lo and behold, it did. So there was some controversy at the time surrounding Title VII, but there was really no controversy surrounding the Age Discrimination in Employment Act. And it's exactly what Mary said. It was a response to employers saying, over 35 need not apply. You know. Here's how, you know, things have changed. And we'll talk about this more. Attracting older workers might actually lead to lower turnover, because what's the stereotype? And I don't even think it's a stereotype anymore. I think it's, you know, pretty well borne out in empirical data of millennials and going to jobs. They go from job to job. I think the average tenure is 3 years, something like that.
Yeah.
So,
and maybe not even millennials, like even into the forgotten Gen Xers before, but yeah, this idea that if I want to advance, or if I want to get a higher salary, I have to go somewhere else to get a different opportunity. Maybe I'll come back to you and work for you again in a few years, but that's the way I'll get a promotion and more money. Yeah.
Right. But yeah, the madman, company man, one career, one employer. That's just not it anymore.
Yeah.
That's just not it anymore. No way.
No golden watch. We'll have our Fitbits or whatever.
No. Right. So here we go. This is small, and it's pretty small in your handouts too. The takeaway here, and this is from the government, BLS. So about let's do the math. 2017 minus 1994. Well, that's 21 years ago. Wow, that person can buy a drink. It's even more than that. I can't even do the math right. It's 17 and 6, 23. So it was 35 to 44 was the biggest group representation-wise in the workplace, and in 7 years, it's going to be the older set. It's going to be 55 and older. So what are we going to do about this, right? How are we as employers going to adapt and embrace this and take advantage, not in a twist your handlebar mustache kind of way, but literally, get added benefit out of an older workforce. One reason why employees are staying on longer is that retiree health benefits are going down, and I'm sure Scott's still around here somewhere. Maybe he stepped out, but yeah, it's expensive going out onto Obamacare or ACA. As I'm told.
Too, yeah.
To get insurance, it's nicer to get insurance. It's cheaper, especially when your employer subsidizes it or pays for it altogether, to stay on longer and get those health benefits, especially when you are staying older. Yes, it is true. When you're older, you're going to have, more likely than not, more health issues than someone who is younger. That happens. We get that. So having the employer pay for that health insurance is certainly an enticement to stay on with that employer longer. Okay, so it was 5%. It was 5%. The percentage of hires that were 45 years of age or older when the ADEA was enacted, 5%. In that first full year, back when the U.S. Department of Labor was the administrative agency tasked with enforcement of the ADEA, there were 1,031 ADEA complaints filed. First year, got to get your legs under you, not many. Here's what it is now: 20,857 that were filed in 2016. And Mary, of those, you don't have to give me exact numbers, just looking at trends, do you see kind of looking at the second layer protected class? For example, are we seeing more women now filing? Is it still many more men who are filing, or women catching up?
It's coming up that women are catching up. I mean, even thinking of just what the workforce was in the late 60s when it took effect, it was more white men initially. And then you started seeing we're getting increases in African Americans filing age charges, Asians filing age charges, and certainly women, in part that you have more women in the workplace. And now, is it also some of the ageist assumptions, sometimes the age stereotyping can hit women harder than it can men of the same age, Look at some of the TV stations. You can have some of the newscasters who are men who've been around for years and years, and the women don't always stay around. Not picking on anybody individually, but just thinking sometimes we still see a difference in who is perceived, or the perceptions with age, and it doesn't always. Maybe I'll do Hollywood movies. I don't want to. Thinking about who has love interest. Jack Nicholson could have a 20-year-old love interest, but you go with Sally Fields from one year she's playing Tom Hanks' love interest, and the next year she's his mom in movies. You still have that stereotypical assumption. So we are seeing more age charges where women are coming up just about the same as men now. The percentage there.
But overall, retaliation is still the boss. That is by far and away the number one charge.
Yeah, 46% last fiscal year. I'm waiting to see when our fiscal year starts October 1st. It takes us a few months to crunch all the data. I wouldn't be surprised if it's even closer to 50% retaliation charges this year. It's gone up every year for the last 4 or 5 years. It surpassed race cases. And you might have more than one charge. It could be somebody, hey, I complained about not getting promotion because of my age, and then I was retaliated against. So sometimes you'll have more than one basis in the same charge.
That's exactly it. I mean, that you said exactly what I was going to say, that the reason, one of the big reasons that retaliation, 2 big reasons why retaliation is number one. It usually is part and parcel with another protected class characteristic that you believe you've been discriminated against, especially when you lose your job. And the second thing is, people, again, don't generally take ownership for the reason that they've been terminated. A lot of people don't think it was, it was my fault, I didn't do my job, there must have been some other reason the employer did this. The employer's so mean, and you check the retaliation box. So there is retaliation. Don't get me
Or
wrong.
people expressed concerns, and wait a minute, going with this, I do think that I understand what you're saying of, it's hard for anybody to admit, hey, I made a mistake, I messed up, particularly if you've been working somewhere for a long period of time. I think some of this goes to the lesson being consistent, and if there are performance issues, let people know early. I think it's a matter of fairness that, you have those conversations and follow up or document things, and then you alleviate that, oh, I was surprised, why am I being selected for termination? I thought I was doing a great job. Well, we talked about this. And sometimes, I think it's easier to say, hey, we have declining sales, we're letting you go. The person, well, wait a minute, then I looked, my friends told me they hired somebody, person comes to us, the employer might say, oh, it wasn't declining sales, it was performance. Well, you've given a bunch of different reasons. Do we have to believe that it was performance? You told the person that it was declining sales. When they went to unemployment, you said it was lack of revenue, whatever. When employers give these different reasons, that can also make people think, well, maybe it wasn't my performance, maybe you're lying, it really was my age. So I think sometimes it is have the conversations early, and if you're having trouble with the conversations, that's also, you can call us for general information, you can call Eric as your attorney, like, hey, how do we broach this subject to try to alleviate these issues later?
Yeah, it's very difficult to put the toothpaste back in the tube after litigation has begun. Depositions are being taken, and the manager is testifying to something different than the HR manager, who's testifying to something different than the coworker, who's testifying to something different than the district manager. Those are the inconsistencies that create disputes of material fact, as we lawyers like to say, that create trials.
That gets it to the jury, like you're candid when you'll talk about it.
But yeah, the communication is going to be a constant theme for that. As we wrap this up over the next hour, and we'll get you out of here 10:30, I promise. Communicating well before litigation. What can we do to help you? How can we help? That isn't just for age issues. It comes up in disability. You're not saying that someone is old. You're not saying that you're calling them out because they have a disability. You're calling someone out. You're asking, what can we do to help you? We noticed you've had performance issues. How can we help? Even for people who aren't having performance issues, we're talking about ways to attract and retain talent. We'll talk a little bit about reverse mentorship programs. We'll talk about just training programs, generally getting into technology, ways that you can train older workers to increase retention and make them feel more comfortable with technology. Yes, it is true that, a lot of kids, I remember, I forget whether it was my kids, I have so many of them now, but or other kids who go up to the TV set and they try and they put their finger across it, sliding it an iPad or an iPhone to try and turn it on, So yes.
How do we do that? Yes.
Kids
I
now.
on the radio when I'm driving sometimes, I find myself trying to oh wait, I want to go back and listen to that again. No, it doesn't work that way. It's not my iPhone.
Right. Kids today are more exposed to technology than kids back in 1967. This is true. We get this. But still, there are ways that employers can help older workers utilize technology in a way that makes them add a lot of value to the company. You combine that with their experience, institutional knowledge, leadership skills. That's a pretty good candidate. That's a pretty good work. Okay. 64%, that's the percentage of workers ages 45 to 74 who believe that workers face age discrimination. I think that number's a little low.
I think sometimes people don't think about it until something happens at work. Wait a minute, or I saw a friend that I thought was doing a great job, let go. What's going on here? Or somebody not getting a promotion. Wait.
So, quick plug. Not specifically for me, even though I am a mediator at the EEOC, but I do want to give a quick plug for the EEOC's mediation program. How many employers in here either have received a charge of discrimination or know an employer that has received a charge of discrimination?
I can close my eyes, but I don't have my glasses, I can't see. I'll go with the
We're not trying to call anyone out specifically, okay? Generally, when you receive a charge, unless it's a really egregious claim on the face of the charge, or it's a really terrible claim on the face of the charge, you're probably going to be offered the chance to mediate. I would suggest, both as wearing my mediator's hat and as wearing my employer advocate's hat, that you strongly consider that. A lot of folks in here, I'm sure, have employment practices liability insurance. I'm sure your carriers are thinking about that because they want to keep the cost of defense down, the amount that gets paid down. It's really a great opportunity to go in. It's voluntary. You don't have to settle. But if you can get into a mediation at the EEOC and it's free.
It's free, it's faster, you'll get in there, you know, it can be a way of resolving everything within 90 days versus months and years for an EEOC investigation or possible litigation by EEOC or the employee.
Saves you from having to write a position statement. If you can settle that case for $10,000 and you have an insurance policy with a $25,000 retention, your insurance carrier is going to be happy. You're going to spend that $25,000 anyway in defense costs. You probably saved yourself $15,000 under that scenario. And worst comes to worst, if you go and it doesn't settle, big deal. At least you got a little free discovery. You learn a little bit more about what the other side's case is all about.
Yeah.
So what the EEOC does, all the settlement agreements there that are struck are confidential. But what the EEOC does is they keep, for aggregate purposes, track of all the money that is paid as part of these settlements. So if I go down and I settle a case for $10,000, I settle another one for $15,000, the EEOC doesn't know that I personally settled a case for 10. Rather, they just keep track of those little 10s and 15s and the bigger ones too, and they aggregate them. And they recovered $88.2 million for ADEA claims.
Either through mediation or settlement during the investigation, or in some cases, if after the investigation, if we've made a finding of discrimination, resolving it there. Yeah.
Okay. So that's 88.2 for all of 2016 for the EEOC. One jury in Camden awarded one plaintiff earlier this year in an age discrimination case $51.5 million. Okay?
We're still doing a really good job. I want to just say that.
Yeah. This was, I forgot the name of the plaintiff, but the defendant was Lockheed Martin. Sorry, Lockheed, if you're watching this video, but we have to talk about this. The plaintiff was part of a reduction in force. This was not a hostile work environment claim. There was no violence. This was a reduction in force where, among others, someone who was over 40 was laid off and believed that they were discriminated against based on their age. A jury agreed. Now, the law firm that handled this, I called the lawyer who I thought was trying the case, and she called me back. She said, "No, it wasn't me. Thank you for the congratulations, but I can't take credit for it." It was two associates who tried this case for the plaintiff. Two associates. I don't want to say young associates, but I know them. They are younger. But two associates. That must have been a tough drive back for the defense lawyer from New Jersey, Camden, New Jersey, down to Atlanta to report to Lockheed Martin. Obviously, they knew the news, but to actually face the music. That a jury just handed down $51.5 million verdict, $50 million of which was punitive damages. So that's how mad the jury was at Lockheed Martin for what they had done in connection with a reduction in force. Yes.
I think, so, you know, with the jury ones, and you know better than I, you know, if there's that identification, if you can see, well, wait a minute, this could have been me. Or the same with retaliation. Sometimes, you know, the evidence is even more blatant than in other ones. But I think wait, that could have been me. That could have been my mom or my dad or my brother or sister, whatever. I think that's powerful with juries.
Yeah. There are certain types of claims that resonate with juries more so than others. USERA, military discrimination. No one likes the idea of an employer discriminating against an employee for his or her military service. So if you go to trial on a USERA claim as a defense lawyer, good luck. Retaliation claims, because it resonates, right? Like either you yourself feel that you've been a victim of retaliation at some point, or you know someone, a family member who has been, it's not too hard to say, yes, this happened here, and age. I think age is, again, you think about a relative or maybe yourself, you get an older jury maybe.
Parents, that something happened, yeah.
Yeah, so that's a tough one, and obviously it manifested itself in 51.5 million. So you alluded to this earlier. Why are people working longer? We talked about the changes to the retirement plans. To going from, actually I didn't, I apologize. Going from defined benefit to defined contribution. So you don't know, unless you work for the city of Philadelphia and you're in the DROP program. I guess that was controversial a couple years ago. I won't get into that. You don't know what you're going to get when you retire, right? You don't know years down the line what you're going to get. You know that my employer is contributing to my 401k right now if I remain. So changes to benefit plans, not knowing what the future holds, but rather kind of hanging on and taking what you can get, encourages, or incentive's a weird word, but it's almost like a reverse incentive.
You're going to stay.
You want to stay.
Do you remember before 2008, we would hear, the articles, there's going to be a retirement tsunami. Make sure that you're doing succession planning. All this knowledge is going to be lost. Everybody's going to retire. And then you had the stock market collapse and people can't retire. I mean,
That's
they're
right.
going to stay on longer.
That's right. The people are living 3 to 4 years longer than they were in 1980. So we just get a naturally older workforce, okay? Increase in the retirement, in the Social Security age. So we're 65, 67, 70,
Is it gone?
whatever it is.
Yes.
It's harder to get your full benefit. You got to hang around longer. And lastly,
Because they
employ-
can.
Yeah,
They're doing a good
because-
job. They want to stay.
Right. You're
You want to be
healthier.
engaged, yeah.
You're healthier. You feel good. Like my job. Get paid well.
Like
feel
my
like I'm doing pretty well.
coworkers.
Yeah.
Want to be productive, make meaningful contributions, yeah.
Yeah. Yeah. So those are just 5 of the reasons. Can you talk about some of these cases? I know when we did it last week.
of these cases.
Karen McDonough, who is the enforcement manager in the Philadelphia District Office of EEOC, didn't want to talk about Texas Roadhouse because she was involved in that case.
Yeah.
I can certainly talk about any or all of these, but basically, I want to talk about one case that's not up there. I want to talk about Sidley Austin. But we've got
So in
6-figure club, the 7-figure club, and the is this the 8-figure club? I forget.
Yeah,
The 8-figure
12
club.
million settlement, yeah. So Texas Roadhouse, restaurant chain, and we alleged that they weren't hiring people for front of the house positions based on age. Some of the alleged comments on Post-it notes were, oh, she's old and chubby, little old lady, middle-aged. Out of 200,000 positions hired over a several-year period, how many do you think were over 40? 200,000 positions nationwide over several years. How many do you think were over 40?
Just front of the house?
3,000, just front of the house. 3,000 positions nationwide. Our experts said that the odds of that happening by chance were 1 in 781 billion. Now, obviously, Roadhouse had different positions, and they did. They pointed to we have an anti-discrimination policy. We train managers. This is not our well, but this is also written policies for anything. You got to make sure that it's not just great words on paper. Are people walking the walk and not putting things on Post-it or letting? And the lesson is not, hey, I'll discriminate based on age. I just want to put it on a Post-it. The lesson is you make sure that that's not a factor in any hiring decision. So we had a 4-week trial, and the jury, it was a hung jury. So then it wound up settling after that. And of course, they denied the allegations. But when we look at any of the settlements in our administrative process or in litigation, a lot of times it also includes some forms of equitable relief that ideally we're not going back there again. In litigation, it'll be injunctions that the employer can't discriminate based on age or whatever the factor is there. Hiring a diversity manager to address these issues so these kind of problems are not recurring. Changing recruitment. One of the things they had talked about, photos used in hiring, and we've had this in some different cases, sometimes with race, but you know, what is the image your company's putting out there on the website, in your materials, in the employee handbooks, things like that? If you're only highlighting certain employees, like, you know, maybe the young and not chubby, I don't know, on there, you know, are you giving a message that these are the only people we want to hire, or this is what the workforce is? So, you know, think about this as the recruitment and you know, what you have on the website, what you're putting out there. For the PMT case, that was also an allegation, failed to hire older women as sales reps. Not a single female hired or older applicant hired over a 3-year period. Now that, you know, again, that just should not be happening. That's not by chance if you can't hire one woman in a position over a 3-year period. That's settled for over $1 million. There was also alleged retaliation against the human resources director who complained about this not hiring. And the Sessions 52, you know, again, that's a restaurant chain nationwide. Allegations that they weren't hiring for front of the house positions. Again, some of the alleged comments that they wanted fresh employees, and we don't want to, our image is not hiring old white guys. So, you know, the thing is not to let people, managers, make those comments. That,
hopefully
you know,
that was
through
documented
training.
in email.
Yes, not in Post-its, not in documents, not in emails, not in texts, and that it shouldn't be a factor in the hiring decisions. And the rent-a-car case, that was a public conciliation. So Eric had mentioned, which is true for most of our cases, you know, everything's confidential in the investigation, conciliation. In some cases, the employer may waive confidentiality as part of the settlement, and that happened in the rent-a-car case, that people weren't, hiring applicants over 40 for certain positions. One of the things that generated a little controversy in the Texas Roadhouse, and I also can't talk a lot about this, but I'll talk about newspaper articles mentioning this part, that under the ADEA, we can do directed charges. We have, under our other statutes, what we call commissioner's charges. Sometimes it comes out, maybe people giving information, and a commissioner under Title VII, under the ADA, they can, you know, if, I'll say Commissioner XYZ, I don't want to name a name, you know, they would say we have reason to believe that there's discrimination going on, and we do the same kind of investigation. You know, we're not weighting the scale that, oh my gosh, we're going to make a finding because it's commissioner's charge. We're going to make sure we're even more thorough in documenting things, but we do the same kind of investigation. For the age law, we can do a directed investigation even if we don't have somebody coming forward. Just because of little differences in how the statute was enacted and the legislative model, the parts of the statute that it was based on. And we had that in Texas Roadhouse. And, you know, some concerns that did this come out from somebody going to a restaurant and, you know, asking about hiring practices and seeing what's going on. But we have that authority. I can tell you it wasn't anything on the scale of this, but I was driving down doing a presentation or outreach somewhere. I was going down in either Delaware or Maryland. So I'm on either Route 1 or 13 at that point. I see a big billboard. We want to hire recent college graduates. I did a legal UB, pulled around, took a picture, sent it to our deputy director. It was a directed charge. It didn't result in any any kind of resolution like those ones. But to contact the employer that, you know, there's something going on with your hiring procedures, that's saying we only want recent college grads. That could be one of those, you know, language things that might deter somebody over 40 from hiring, so they change the advertising policies. Yeah, so again, the lesson, not just don't put it on a Post-it, don't let it be a factor in the hiring decision.
Right. Sidley Austin. So Sidley Austin was, how many years ago now?
Oh gosh.
About 10?
At least, yeah.
Okay, so Sidley Austin's international law firm. I hate to pick on the state of Georgia, Lockheed Martin and now Sidley Austin, but so yeah, Sidley had an issue with apparently trying to squeeze out allegedly some of the older partners, ostensibly because of age, and that case settled for $26 million, something like that. That's the 8-figure club, definitely.
I think so, yeah. I mean, that was a big one. And kind of, you know, it was one of those ones out of the Chicago office, and looking at it, I know for me it was like, wait a minute, you know, when we look at ADEA or any of our statutes, you're looking at employees. And traditionally we looked at it when you're a partner, you're part of the owners, you know, you're not just an employee, you know, but when you have such a, you know, major national, international law firm, with so many partners, even though somebody might have partners, you really have different levels of partnership. And if they had bought in and had that partnership title, but they weren't directing the decisions or the direction of the law firm, you know, then we argued you're still an employee. You're not really one of the owners on that, and that's how we went forward alleging age discrimination. So it was kind of, you know, kind of a little shakeup, I think, in the legal framework, and then looking at other employers that have that partnership model. You can't assume that with the title that it means, hey, you might not be subject to these laws.
If I remember correctly, though, since then, Sidley Austin has been voted many times over one of the best places to work in America.
See,
So
then the
clearly
positive
they've got
impact
that.
of EEOC intervention, right?
Yeah. Do you want to talk a little bit about, we have about a half hour left, do you want to talk a little bit about how the ADEA and age bias and addressing age claims fits into the EEOC's strategic enforcement plan?
Sure. So over the last few years, we have what we call our strategic enforcement plan, our SCP priorities. Are there things that class-based recruiting, hiring practices? If an employer is only going to college campuses, who are you likely to get? You know, you're probably going to get people, odds are, under 40. And other ones, you know, if there are other policies, barriers, Eric talked about the idea of disparate impact. The employer might think that we're applying this neutral, but it has that effect of screening people out for whatever that reason is. Channeling, steering. Okay, we might hire people over 40 for some positions, but not maybe where they get more money, or we're not going to hire them for front of the house positions where our customers are going to see them. Those are some of the allegations going on there. Any policies, practices, restrictive application process. Yeah, Eric mentioned LinkedIn, but you know, what if you're only using certain websites? Are you still making sure that everybody has access to the information? And that goes beyond age. I mean, anything for having a good, you want the biggest pot possible, as many applicants, that you really get the best qualifications and the best different viewpoints. I think one of the key things with diversity when we're looking at it, you don't want like the same thing. You want different perspectives because it leads to a better workplace environment and new thinking strategies from younger workers, from older workers, from different perspectives. The same with screening tools, job segregation, you know, the front of the house, back of the house kind of things. And with the application process, if you're doing things online, does it time out? Or if you have kiosks, does it time out? Sometimes you might need to give accommodations because of disability. That's, you know, not really tied in with age, but you know, you might have to modify policies like that. One of the reasons for the strategic enforcement plan, you know, just trying to be as effective as possible in addressing discrimination. We get, and if you want to say on average, let's usually the most typical range is in the 88,000 to low 90,000 nationwide in a fiscal year. We cannot bring cases, nor are we designed to bring cases in court in every one of those, even if we make a finding of discrimination. We have to be strategic in how we focus our resources in investigations or possible litigation if we make a finding and we can't resolve it. And that's the idea of looking at these broad-based patterns and practices to try to, you know, have the biggest effect nationwide and, you know, make positive changes in the workplaces.
Yeah. I want to be clear about one thing. You know, with age, there's no duty to accommodate someone because of their age, as there would be, let's say, under the Americans with Disabilities Act or under Title VII with respect to religion, accommodations.
Yeah.
But as I said before, you know, the older the workforce gets, unless you have a really great wellness program, you know, you're going to see older workers statistically tend to be the ones who physically can break down a little bit and may have a disability, a record of a disability. You may regard them as
make an assumption. You're
right.
old, or are you going to drive up our healthcare costs? We don't want to hire you.
Right. So
what's going on.
Regarding someone as, because they're old, as disabled, you're violating not just the Age Discrimination and Employment Act probably, but also the ADEA. But if someone has an actual disability, young or old, but let's focus on old, if they're not, you don't have to accommodate them because they're old, but you may have to provide you would have to provide a reasonable accommodation if it exists and doesn't create undue hardship for someone who is older, who has a disability, who needs it.
And they have to let you know. You know, employers don't have to be mind readers on this. We don't like to think about it. We all want to hit the protected age group. We all want to get over 40 because, what's the alternative? We don't want to think about it with the ADA, but odds are we or one of our loved ones or a friend is going to have some disability. It could be a car accident, it could be a heart attack. We don't like to think of these. So that's why we have to be open. I mean, I think when you have a current job, we kind of assume, well, yeah, if something, heaven forbid, if something happened, if I had some accommodation, I'd be able to keep going. We don't always give that same benefit of the doubt, I think, maybe to applicants, and think about, maybe we get scared or intimidated or have stereotypes or assumptions that people with certain impairments couldn't do the job. So I think, be open on that, yeah. So I didn't mean to suggest that there's an accommodation for age, it's not, but it might be tied in with disability.
Yeah, and let me further separate the two. If you have an employee who is getting older, who, because they're getting older, can't perform the job like they used to be able to, and maybe can't perform the job, can't perform the essential job functions, they don't have a disability, they just can't do it anymore, and you terminate their employment, you're not terminating them because they're getting older. Let's be clear about that. If Cole Hamels, who is now on the Texas Rangers, he's getting older. If he loses a couple miles an hour off his fastball, and the Texas Rangers decide, you know what, you're not going to be our starting pitcher anymore because you can't, you're not hitting at least 90 miles an hour on the radar gun with your fastball. They're not discriminating against Cole Hamels because of his age. He's no longer a starting pitcher because he can't perform. So I say that with age because there could be a correlation. But if someone any age can't perform the job anymore and there's no disability at play, it's obvious. You don't have to keep them on anymore. You don't have to walk on eggshells thinking, oh, is this going to be an age discrimination claim? Well, no, it's not. This person can't perform the job.
Or it might be a claim. It doesn't mean there's going to be a finding.
Right.
But you focus on the ability to do the job.
Mm-hmm.
The Cole Hamels, that's when you're already at a level that most people will never be able to do. That's one thing on it. And think about, you just can't make assumptions that because somebody's older, they're always physically not going to be able to do the job. And sometimes, as people have seniority, they can do something faster than a new person still learning the job. So you can also have the positive effects of age and seniority there. But I think we're on the same page. Looking at the ability to do the job.
Exactly right. And it comes back to there's nothing wrong with saying to someone, what can we do to help?
Yeah.
Whether it's age, whether it's with a disability situation. You might not know about someone's disability. It may come out as a result of saying, what can we do to help? And then when you help that person, the morale boost, the positivity that comes from that, if the employee can then really get back to the level that they were, whatever you did to help them, you have a happy employee, happy employer. That's a great thing, as opposed to, without having said, what can we do to help, not communicating with them. Their performance goes down. They lose their job. They think it's because of age or gender or disability or whatever, because there's that lack of communication about what the expectations were and why the employee wasn't hitting those expectations. Those are the ingredients for an EEOC charge. Whether it's a viable one or not is a different story, but communication is so key.
Yeah, and as you flip to the next one, I think, make sure the communication with the frontline managers and supervisors as well, because it's usually not the folks that are in these training rooms that are the issue. It's sometimes, that first level, that's going to create problems. And they might have had, when are you giving them training and how often? And when you're talking about training, a lot of times, you might be looking more at, sexual harassment. We know we got to worry about harassment. Well, if you're worrying about sexual harassment, you should be worried about making sure racial harassment, national origin, religion, age, all of them are covered. But make sure that as you're talking about this commitment for including age in your diversity and inclusion commitments, see how you talk about it in your training as well. And when do you give managers training? If you wait until they've been on board for a while, or you had training when you were first hired, how much, think about everything you learned when you're first hired. You might not be thinking of, what does this mean when I have to make these difficult decisions? So, I think have that conversation with the managers and supervisors to make sure they're not letting these impermissible factors influence decisions, and that they, can have the difficult conversations if needed.
That's right. All right, so the next 3 slides, I decided to go on to Craigslist and search the want ads. Not because I'm looking to to be not because I'm a hip, fun, talented
You want to hit
individual.
fun, talented, to
But
contribute and grow with us.
Yes. I was thinking along the lines of what you talked about earlier, perfect for recent college grad. That could be problematic, but it gets worse. Here's one specifically looking for a hardworking young person.
What's the anniversary of the age law again this year?
Yeah.
50th anniversary. Maybe one of these years we'll let people know. They'll get the message.
In fairness to most employers who advertise on Craigslist, I didn't
They
find
probably
too
don't.
many in the area who were specifically looking for a young person. But here's a law firm that was looking for a young attorney. This is an opportunity for a motivated young attorney. I had to just, I didn't know. I felt bad. Kind of brothers in arms, that kind of thing. I did. But boutique litigation firm. They're a young firm apparently. So they're looking for a motivated young attorney. Who would work under the supervision of an experienced litigation attorney? Apparently not.
They're just not experienced in employment litigation. That might be the issue.
Right. So it's out there. You don't have to look hard for it. As we were kind of our banter earlier, there are other buzzwords. We saw hip can be recent college grad, digital native in the tech arena. But yeah.
And just because kids grow up, and it amazes me how young, that they can figure things out. Let's get to YouTube fast on the iPad, all of this. But it also doesn't mean that just because they've grown up with that they know how to do spreadsheets or programming. I think sometimes we give more benefit of the doubt. It'd be like, we grew up with TV. It didn't make me, able to do, I don't know, camera work or repairs. We make those assumptions.
Yeah, I think this is like 2 degrees of Kevin Bacon away from old geezers need not apply. Let's see. Okay, so let's talk about ways to help attract, train, and retain older workers. And we can kind of riff back and forth on this. Stereotypes, right? Stereotypes happen across the board. It's not just with age. Often see with disability. You're concerned that someone has a disability, they automatically can't perform the job when all it would take was just like a little accommodation, something very small and reasonable to allow them to do it. But avoid these really outdated assumptions. Younger workers are a better investment because they will stay longer. No. Again, we'll bash on the millennials. They jump a lot. Older workers do want the training and new opportunities. You've put in time. You have experience with a company. Maybe whatever position you're in, it's the position is not static. It changes, and the employee wants to change with it. But the training module is something that is more geared towards someone who has more experience, who grew up with tech. Maybe it's a learning module that someone's got to take on their own, versus if you had just had a trainer come in to get the ball rolling, a physical person there to help with the training, to answer some initial questions, and then put some of the older workers, or any worker for that matter, into the training module. That's the only push and guides that they would need. And the older worker is going to pick it up and learn it like that. It's going to be great, just like anyone else would.
And I think it's, with any of these, the heart of stereotyping. I mean, we assume the millennials will want to do things tech-based. And maybe some people also like having a training class. I mean, we all have different ways of learning. Some it's, I want to hear things. Some I want to read it. I might want to read and then hear it. So, it is giving those different modules to have a better shot at success. We had a recent, the EEOC's task force report on harassment issues, because over 30 to a third of our charges included some allegation of harassment, even though those protections have been on the book for decades. So some of the recommendations that the task force, led by Commissioner Feldblum and then Commissioner, now Acting Chair Lipnick, and with input from the employer community, academic community, employee community, looking at the training modules. And sometimes, one of the things they talked about in the harassment context, the importance of having a live trainer, because of showing the commitment, the opportunity for asking questions and follow-up and generating that conversation. So it's good for the older workers. It can be good in other contexts as well. And not to knock if anybody's doing the digital training or develops those, they can be great. But if you've had a bad one where it's like, yes, I hit next, you know, we used to have a security one where I could every year, no, I won't leave my laptop by the pool, next, you know, just if it's not a good module video, you're not getting good training for anyone.
You know, we can all send an email, we can all send a text message. Apparently some of the older folks have to, you know, hit the number 1 3 times to get to C or whatever the heck it is, but you know, people can learn Yammer and Slack. I mean, technologies that the kids use, it's not just for the kids. I mean, we can use them in the workplace, older workers too. I like, where's the one about do we have the age panels up here?
I think that's the next
this
slide.
Is it. Oh, is it the next
Or
slide?
as well.
Okay, so
yeah.
I won't skip ahead. But I mean, these are just some basic items.
I think, you know, focus on qualifications. Like, does anybody think when I'm hiring, I'm not going to focus on qualifications? Like, that seems kind of like a duh. We want to think that. But I think sometimes it's very easy, or maybe easy in interviews, to get that kind of confirmation bias and wanting somebody who looks like us, or, you know, I like this person, and then you give them more points that, oh yeah, they have to be the best qualified for it. If you really kind of assess it from the beginning and really try to look at where are the objective things we need, you know, then you're not getting swayed for a different bunch of reasons of, you know, is this a way of not getting as many older workers or African Americans or women for certain jobs? So I guess it sounds obvious, but it's not always as easy to implement to get on that.
I've got some easy ones, like on the
There.
job application, don't ask for someone's date of birth.
Oh gosh.
Don't ask when they graduated high school.
Mm-hmm.
You know, you may be able to tell from someone's resume if it's a 3-page
ask
or a
for photos,
4-page.
yeah.
Right, don't ask for photos. I mean, if it's a 3 or 4-page resume,
Mm-hmm.
hopefully if you're older, you're smart enough to condense it, right? You don't
Yeah.
want to call yourself out as someone being
Then
as
I
someone
worked
who's
at
older.
this restaurant when I was in high school,
Right.
living, yeah.
Right, but not specifically asking for someone's date of birth. That's pretty obvious.
Mhm.
Yes, you can get into that later on. Obviously, when someone's doing onboarding paperwork, you're going to need to know someone's
Yeah.
date of birth and things like that for I-9 purposes or tax reasons, but not when you're in the hiring process. I like this, the age diverse interview panels.
Mm-hmm.
I saw one of the experts who was asked to present at the EEOC's public meeting on ADEA at 50 was talking about how people like to hire in their own image.
You look like me. We went
Yeah.
to the same school, or I feel like you
Yeah.
know, we can go have a drink together or hang out together or whatever. You're just like me. Yeah.
So having a variety of protected classes, let's just call it that, on the hiring panel with a standardized set of criteria.
Mm-hmm.
So that way you're not treating people differently in terms of the qualifications you're looking
Yeah.
for, but at the same time, there may be different ways to relate to the candidates.
Mm-hmm.
That, I think, promotes you get what you're looking for in terms of people who can do the job, but you get that diversity that you may not
Yeah.
otherwise get from one person who
Mhm.
does all the hiring, or two
Yeah, the
people
different
who do all the hiring.
perspectives, you know, different people can zoom in on different qualities or experiences. It's just going to be a better employment pool and better hirees.
This is, you know, if we had done this a year ago, we'd be talking about shared workspaces and telecommuting.
There's my
I guess-
age bias, shared workspaces.
I guess we're still well, apparently WeWork is a $20 billion company, or at least that's what WeWork thinks. But yeah, if you've been over to WeWork, which this isn't
Oh, that makes sense.
to
Yeah.
bash
I just wanna share
WeWork.
my
and
own.
WeWork is there are many locations
You're
in
right,
Philadelphia, shared working space.
Yeah.
It's kind of like, you know, my version of Starbucks. But they have open working spaces, they have conference rooms for meetings, they have private workspace. But it's the whole idea of just doing things not the way it was done 15 to 20 years ago.
Mhm.
So with flexible work options, we see some employers now, especially the tech industry, IBM, calling people back to work. They think there's
Too much work at home.
value in collaboration and face-to-face. You know, at a law firm, for example, there is a lot of value to be able to walk into a colleague's office and just bounce ideas off of them versus doing it over email or
Even
a
a
phone
phone
call.
call.
Yeah, I mean, you can do it, but there's something about doing it kind of face-to-face that may be a little bit more effective. But that doesn't mean that you get rid of flexible work options altogether. In fact, if it's going to allow people to be more productive, you're going to see that value, then consider it. It's, again, nothing new, but it doesn't just apply to the millennials. It doesn't just apply to folks who have a disability, who may not be able to make the commute into the office, who need to work from home because of a disability. It applies to the older workforce as well.
I think,
go ahead.
with the work options, so we're also thinking part-time work, full-time work that way. I mean, that can make a big difference if you're in the sandwich generation, maybe caring for kids, but also caring for older relatives. Be flexible, or I guess maybe go back to looking at your qualifications when you're hiring. If somebody's been out of the workforce for a while because of family care responsibilities, don't knock the person if they, just because they might not have had a recent 5 years experience, if they've had a lot of other great experience, just be open to, again, having the broadest pool of applicants and considering that way. So those are some of the obstacles I think maybe for older women that aren't getting hired. Maybe they've been out of the workforce for a little while, caring for kids or other family members, and just don't knock somebody because they haven't had 3 years of recent experience.
But that also gets into, we allude to the big data and the algorithmic way that more sophisticated employers and now some less sophisticated employers who are trying to catch up are hiring, right? You just have an algorithm. You go out, you search generally online to find applicants, and in your example, Mary, if someone has taken 10 years off for caregiver duties, I'm guessing the algorithm's probably not programmed to kind of give that person the benefit of the doubt for those 10 years. So technology is always going to outpace the law.
Yeah, we're always trying to catch up, yeah.
But at some point, if technology is, you're getting that disparate impact type situation, where someone isn't intending to discriminate, but that's the net effect, that you have a class, whether it is age or race, religion, gender, whatever, that is facing the disparate impact, then those algorithms and that technology, the data is going to be tested. It's going to be tough.
Yeah.
It's going to be tough to prove. But yeah, it's going to be tested. So, kind of do some self-reflection, right? When you have a hiring system, every once in a while check it. It's different, but it's the same as, I go out and preach kind of proactive stuff that you can do in the workplace to prevent against potential discrimination claims, as simple as workplace training. Folks coming here today to get trained on ADEA. I mean, there's always time to kind of stop and look and see, what are we doing? Is it turning out as we planned? Are we unintentionally?
Do the audit of your hiring patterns,
Yeah.
before EEOC or OFCCP if you're a federal contractor, if you had somebody looking, wait, we haven't hired any women in 3 years, what's up with that?
Right.
If you do that and be proactive, it can, and that from our perspective is wonderful. It'd be great. We want things to be done well in-house. It's much better result for everyone if there's not discrimination than if there is and they have to come to us to try to remedy it.
Right. Chippendales, that's okay. Texas Roadhouse, it's a problem if you're discriminating against women. I guess they were older women too, I suppose. I love this idea, the reverse mentorship program. It started with one of the tech companies, larger, I think it was Cisco, or maybe Intel, I think it was actually, out in Silicon Valley. Target's doing it, United Healthcare's doing it. Usually it's senior leadership that gets paired with younger employees to basically kind of learn from each other and exchange ideas. It's not just how to bring the younger folks up through the company, but rather what can senior leadership learn from younger employees to essentially kind of reshape the business, both internally and outward facing. But I see no reason that this can't be done, but aside senior leadership, but with employees with more experience, who tend to be the older employees, pairing them up with newer, younger employees, and for them to kind of, like we saw in the video, learn from each other, and kind of leverage their respective talents for the benefit of not just themselves, but for the company.
Yeah, I mean, it's giving the newer workers insight into what it takes to succeed, or And maybe they, well, I don't want to do it this way. Why can't we do it this? Well, maybe we had considered this, and this is why we have this process. But the flip side, maybe we do need to reevaluate a process. I just think that continual learning, it benefits everybody.
Yeah, and let's put a big fat asterisk on everything that we're saying about recruiting, training, and retention. Maybe you shouldn't just listen solely to two lawyers talk about how businesses can run their business. I mean, we know the law. We know what we hear from experts who are talking about this. It seems to viscerally it makes sense. But these are just meant to be like a starting point. Don't listen to us as if it's the gospel.
I think on EEOC.gov we have on the front page like a nice little icon you click for ADEA at 50, and it brings you for some of these hiring suggestions or recruitment to ARC pages, or that you can see what has worked with other companies. If I give a plug on some of our other things with hiring, I think from the EEOC perspective, a lot of times we'll give kind of overlapping advice in different contexts. But if you look at best practices on preventing discrimination against workers with caregiving responsibilities, not knocking people because they've been out of the market. Look at some of our best practices under the E-Race initiative, eradicating racism and colorism in employment. We try to have a lot of different tips in hiring in different contexts, and go and see what works and get these broader suggestions to have more perspectives than just Eric and mine.
Or go click on the page that has all the verdicts and settlements. That'll scare you.
Yeah. We want to give the carrot, but then you see the stick as well. Yeah.
Gotta unleash the stick. I think we're pretty much at the end. Yeah.
Yeah.
So for the last 5 minutes, if folks have questions, we're happy to answer them. And
went fast.
I know. And if you don't have questions, you get out of here 6 minutes early. So we're happy to hang around after this question. Yeah.
I have a question. You had mentioned earlier that if you put in a, say, job posting looking for 3 to 5 years experience, are we to not put a number, just put experience in whatever field it is? But then how do you prevent people applying with no experience, or then you have people that apply with all this experience that you don't really need?
Two things. One, I think the easy way to get around that is say at least 3 years of experience. If you want to set a floor, I think in reality, if you say 3 to 5 years of experience, that's not the lowest hanging fruit on the tree. Tell the legal industry that we can't do 3 to 5 years experience when we're looking for an associate. Now maybe the EEOC decides, hey, we're going to target the legal industry and get rid of this upper cap. But I think the safest way to do that is say at least 3 years experience, and then as the resumes come in, you can tell anyway.
Yeah.
You're probably, even if you said 3 to 5 years experience, you're probably going to get people who apply that have more than that. You just look at it and go, all right, maybe I'm not really interested.
Or maybe just don't make the assumption I'm not interested. I mean, but this is, again, maybe it is more EEOC perspective. We're not saying that you can't hire newer people in the industry. I just think from ours, think of the impact and don't refuse to hire people with more experience because of assumptions that, oh, you're too wedded in your ways, we can't train you in ours, or you're going to be too expensive either salary-wise, healthcare-wise, or whatever. Don't let, you can have certainly minimum qualifications as long as it doesn't, there's not some kind of adverse impact screening tool going on. But just don't let it be a mechanism for weeding people out, that we're not going to consider people who are over 40, or maybe somebody who's changing jobs or have been laid off, and it's going to be a lower salary, but they would be a great worker,
Oh, and by the way, we should have done this at the beginning. Disclaimer. We're both lawyers. We understand that every question is hypothetical. Every question is hypothetical. You're not talking about your own workplace. And nothing. I'm from Dilworth Paxson. I don't speak on behalf of Dilworth Paxson. Mary's from the EEOC. Shouldn't speak on behalf of the EEOC. We're not giving any legal advice here, although it sounds like it. We're really not. I'm not sure how that works, but we're really not. And we're not
sharing perspectives.
We're not trying to create any attorney-client relationships today by answering questions, but down the line. But anyway, thank you for the question. Yeah, thank you for the question. What else can we help you with? Yes.
I just want to note that one of our manufacturing clients, we're seeing a lot of older people get called back, and the reason we get involved in it is they actually saw the pension plan, so they get into suspension of pension benefits. So we're calling older guys to come back to work.
Oh, wait, because they,
They are in pay status.
okay.
So, you know, you are seeing some older workers come back when they need skilled people who know a specific area in manufacturing.
Good.
Good.
I think the goal, just the goal, we want everybody to have the equal opportunity. I mean, we feel like that we're advancing, that's part of our mission, and for any of it, I mean, we talk about here, ability not age, but that would go with any of them. Ability not sex, ability not pregnancy, ability not race, any of them. That's wonderful. That makes me leave the door with a smile on my face hearing
All
that.
right, let's end on a positive note. We'll hang around afterwards if anyone else has any questions or just wants to chat for a bit, but thank you everyone for coming out today. Hope you enjoyed it, and we'll have more seminars like